and also constitutes the main idea of American realism in the sort of laws and legal system. Then the jurors or jurists would be required to be trained of national economy, fiscal administration, operation of the governmental budget, and the operability. What does it actually implicate, a fiscal or sustainability? How do they view sequestration from Congress against a deprived status of presidency? So it defends to stand on the spending power of Constitution. So actually expenditure has been planned, but it could be sequestrated as a matter of Constitution. How do we contravene the express terms or provisions of Constitution? If latitude is given to the justice or others, then we need to have discreet eyes or sense to look behind the ambiguities of Constitution. That also could be complemented with the kind of information provided by background sources, interdisciplinary approach to crystallize the main thought into a plausible court opinion solution is very difficult, but is demanded. Of course, principally because it could match up to elevate the standard of justice and agreeable result shared by a public generally. So once we have encountered some awkward result from Supreme Court of the Republic of Korea, you see what the statutory requirement has been stipulated at the age of 13, when the issue of a sexual harassment or the statutory rape has been raised involving junior girls and others. The Supreme Court has no way to avert the express stipulation. Notoriously identified in these terms. So legislative suggestion would be expectable, as you will see from the reporter of newspaper article or correspondent. So actually, you see, it is very unsuitable if we enforce the kind of outdated mode of outdated deals of criminal statute. What is a certain age? So the girls above the age of 13 could have a free will to have sexual intercourse with male person or others. How do you perceive this procedure? Based on our general sensibility of justice. Do you consider 15 years of girl the kind of adult to give a voluntary consent to the sex, sexual relationship or sexual activities? Of course, that depends on the situation. Nonetheless, the case was critiqued squarely from points of consideration by generally concerned people or public. So, kind of legal system is the product of society. Fiscal aspect, economic circumstances or history in the nation, and social lens to what actually the judge need to possess the kind of capability to draw upon insights about his background information. So I generally suppose you will have a basic formality in a system and institution involving the United States legal system. So the printout born on 2 pages would depict very basics about the legal system. One is hierarchy of court in charge, and the other would diverge the federal agencies in bureaucratic fashion. So what command and authority has been expressed in a box form. So the United States Supreme Court under that highest court will see 3 appellate courts, what appeals from state high courts, and U.S. Court of Appeals for Federal Circuit, and U.S. Court of Appeals. It generally termed as a 12 circuits, and you will see federal district level of court. 91 U.S. district courts have been charted into one box. Actually, it has been distributed into based on geographical terms or distribution. 91 and various administrative agencies, and also you will find U.S. tax code as one of federal district level, and Code of International Trade. This code is fairly special to administer the trade justice. So the federal agencies, including the Department of Commerce and International Trade Administration, have been subject to the review of this code. So the federal agencies in these kinds who dispose resolution or decision about many trade controversies or disputes. So they are responsible to implement kind of trade laws, tariff acts or omnibus act, many trade acts, and they will also enforce a safeguard measure. A USTR or the safeguard measure, an anti-dumping investigation or subsidies measure would be concerned by these federal agencies, Department of Commerce and International Trade Administration. And in sure cases of trade dispute, the USTR would be an important agency in charge of administration, kind of a safeguard measure, or Super 301 is the measure perhaps less susceptible of a judicial control. USTR is generally seen as political, and whose institution is only subject to the control of President's office. Nonetheless, judicial standard could be developed. So we consider it could be amenable to the court discretion in some cases, but will be expected to be limited by many statutory apparatus or mechanism. And U.S. Claims Code is responsible to administer a small claim. So consider the peer concept in the Republic of Korea, where the generally summary procedure about the small claims, and various administrative agencies would also be pertinent to the understanding of basic forms of interaction or function of a cause and business. You also have another chart depicting the line of a state court or survey. A state high court must be placed at the top of that chart. And you will see in the second row, International Appellate Court, and also you will find a Superior Court, generally Appellate Court, responsible to review the appeal case from district level of state court. So we will find several state courts at district level, probate court, county court, a municipal court, and family juvenile court. And you also be excited of some special court, a justice of peace, police magistrate, so very entangled with our routine days of life. So small petty crimes would be responded by this court. Fine. And also, actually, I like to introduce one insightful case named Regina versus Oji. And so my point is about your approach between formality and kind of a substantial foster of many elements in society. So I just accepted two basic diagrams which depicts the judicial system in the United States and also federal agencies in the United States. That would allow you to grasp the American system basically in terms of its formality and the kind of structure. And nonetheless, you still need, you are required not to lose a basic insight into the genuine feature of legal system. I stressed many points, sociological way of approach, kind of a fiscal administration, fiscal aspect of government, national economy, social justice, and also the judicial style, distinct and embedded in the common law system, the kind of critical role of common law judges in defending public interest, and also as well as important assumption, the kind of classic idea, property or right, freedom of contract. How do you intermingle the kind of various challenges from values or beliefs? So that is a critical aspect that the jurors and judges should pay attention to. And also, importantly, the progress of society has to be infused into the minds of each justice. Actually, the society is dynamic and transformative, especially in the recent years of development, kind of online development, and kind of new understanding of capitalism. Many variants that need to be sought to incorporate into the laws, the legal system. That is my point. And additionally, I like to introduce one case titled Regina versus Ogilvy. Decision appealed by the Crown by way of a stated case from a decision of magistrate acquitting the accused of a charge under the Small Birds Act, RSO 1906, 72402. The facts are not in dispute. Fred Ogilvy, an Indian, was riding his pony through Queen's Park on January 2nd, 1965. Being impoverished and having been forced to pledge his saddle, he substituted a downy pillow in lieu of the saddle. On this particular day, the accused's misfortune was further heightened by the circumstances of his pony breaking its right foreleg. In accord with Indian custom, the accused then shot the pony to relieve it of its awkwardness. The accused was then charged with having breached the Small Birds Act, Section 2 of which states, anyone maiming, injuring, or killing small birds is guilty of an offense and subject to fine not in excess of $200. So the kind of petty crime can be imagined, as you see. The learned magistrate acquitted the accused wholly. In fact, that he had killed his horse, not a small bird. With respect, I cannot agree. So pony is small, kind of a horse, as you know. In light of definition section, my cause is quite clear. Section 1 defines bird as a two-legged animal covered with feathers. There can be no doubt that this case is covered by this section. Counsel for the accused made several ingenious arguments to which, in fairness, I must address myself. He submitted that the evidence of the expert clearly concluded that the animal in question was a pony and not a bird, but this is not the issue. We are not interested in whether the animal in question is a bird or not. In fact, whether it is one in law. Statutory interpretation has forced many a horse to eat bird seed for the rest of his life. Counsel also contended that the neighboring neighing noise emitted by the animal could not possibly be produced by a bird. With respect